abroad. He has land in Pakistan. He wants to dispose of his property. How can he do it? When he is living out of the country, when the land is in Pakistan, he wants to sell it. How can he do without coming to Pakistan? But he has no chance to come to Pakistan. Then, in order to dispose of the property, an agreement is to be entered into. Terms and conditions are to be settled. Agreement is to be reduced into writing. Then deed is to be executed. It is impossible for him to perform all these functions living outside Pakistan. The answer to this question is given in Section 183 Contract Act 1872. Section 183 of this Act lays down the rules that any person who is of the age of majority, according to the law to which he is subject, and who is of sound mind, may employ an agent. This section enacts that any person who is of age of majority and of sound mind is competent to employ an agent. Viewing from the language of this section, it may be understood that the person competent to contract may employ an agent. If a person is not competent to contract, he cannot appoint an agent to enter into a contract on his behalf. Even if a minor appoints an agent, he cannot enter into a contract because the act which he cannot perform shall not be performed by an agent. In simple words, it may be said that such agency is not valid because the person who is creating the agency is not competent to enter into a contract. So the agency is not valid. The person creating agency is principal. Agent and principal have been defined in Section 182 of Contract Act 1872. It says, I'm going to read out. An agent is a person employed to do an act for another, or to represent another in dealing with third person. The person for whom such act is done or who is so represented is called principal. So there is a principal and there is an employee who is known as agent. The bare reading of this section shows that an agent is a person authorized to do an act on behalf of the principal or to represent him in dealing with a third person. So the agency is created between principal and agent for the purpose of entering into any agreement or entering into any contract with third person. So when an agent is appointed, he will have the same powers as the powers given to him by the authority of the principal. So the principal, when authorizes him to do a particular act, then that particular act will be performed by him as if that has been done by the principal. The term person is wide enough. What does person mean? It is wide and includes artificial persons. It includes juristic persons. It is seen that an agent is employed. Employment may be of two types. One is express employment and other is employment by implication. These are two types of appointment of agent. Express employment, employment by implication. Express employment means that he is employed expressly by the principal. When agent is employed by the principal himself expressly, then it is express employment. It is very simple that an agent is an employee of the principal. If he is not an employee, then he is not an agent. And when he is not an agent, the employer is not the principal. So in order to create an agency, he must employ an agent. So the second point is employment by implication. When agent is employed by the conduct of the parties, he is an agent. Suppose you have some grain at your home, you want to dispose it off. You take it to a shopkeeper and hands him over to sell it on certain terms and conditions. So you have employed him for the purpose of selling the goods. Then he is your agent. So this is called by implication. Agent by implication. When there is no express terms and conditions, when no expressly given by the principal, but by his act and by his conduct, he is appointed as an agent. The purpose apparent is to perform an act or represent another person in dealing with third persons. So this is the crux of the principal and agent relationship, that the purpose apparent is to perform an act or represent another in dealing with third persons. On employment of an agent, agency is created. So the agency is creation of employment. When a person employs another as an agent, the agency is created. In ordinary legal parlance, agency is relation between two parties, created by agreement, express or implied. It is essentially a contractual product. So there is a contract between the agent and the principal, or between the principal and the employee. So this relationship is contractual. The relationship of principal and agent cannot exist without consent of both parties. If a principal appoints person an agent and that person is not willing and ready to perform the function, then he is not an agent. Both should be in agreement. with one another, with each other, in order to appoint an employee or an agent. It may be said that it is dual relationship of principal and agent. Rights and liabilities of the parties flow from such a relationship. In broader sense, agency includes every relation in which one person acts for or represents another by his authority. In restricted sense, it is the relation which results when one person authorizes another to act for him with more or less discretionary powers in business, in dealing with third persons. We may say it is representative relation, or it may be said as fiduciary relation. Section 184 of Contract Act 1872 imposes a criteria as to who may act as an agent. I am going to read that section. As between the principal and third persons, any person may become agent, but no person who is not of the age of majority and of sound mind can become an agent so as to be responsible to this principle, according to the provisions in their behalf herein contained. So this is the plain language of section 184. We see that no consideration is necessary to create agency. So far as a contract is concerned, it becomes enforceable only when there is a consideration. And the contract of agency, in spite of the fact that it is a contract, it does not require any consideration. No consideration is necessary to create agency. So there has occurred a difference between a valid contract and the contract of agency. In contract of agency, there is no consideration. There may be consideration, but it is not requirement of the creation of agency. We saw that an agency could be express and implied. This aspect has been clarified by section 186, Contract Act 1872. In order to properly appreciate, you may go through 2004 MLD 477 2000 YLR page 3035. The purpose, time, and extent as stated are determined by the principal to cater the needs or to achieve the objects which he aimed at to have through creating the agency, and which the agent is intended and expected to accomplish in the above matter. A third person have no part. He does not play any part in it. They are all concerned of and are determined by the principal alone. So there is a principal and there is an agent. It is a contract in spite of the fact that there is no consideration. When an attorney enters into agreement, the agreement becomes binding on the principal. I may say that the act of attorney is act of principal. Once an attorney is appointed, once an agent is appointed, when an agent is employed, and he is entrusted with certain duties, powers and liabilities, then when he performs his duties in accordance with the powers given to him, those acts which he will be performing are binding on the principal. A written contract is not necessary. For the purpose of creation of agency, a written contract is not necessary to create an agency. Such a contract may be spelled out or inferred from the circumstances and conduct of the parties. Ordinarily, there is a power of attorney, but that is not requirement of the law. It may be without writing, and it may be spelled out or inferred from the circumstances and conduct of the parties. It is written to ensure the third party that agent is competent to contract. It is reduced into writing as a piece of evidence. It becomes evidence for the third persons, so that he may feel himself safe for the purpose of entering into a contract. If a person orally says that I am attorney, the third person shall not be in a position to accept him as such. So the writing is given. It is written to ensure the third person party that an agent is competent to contract. In order to further elaborate this point, you may see PLD 1985, Supreme Court, page 298. An agent is not all powerful to do all what principal can do, but there is some extent and limit of his authority. An agent is entitled with certain powers to certain acts. He may have certain powers to do certain acts. Section 188 says, an agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such act. An agent having an authority to carry on business has authority to do every lawful thing necessary for the purpose are usually done in the course of conducting such business. I am again going to read the same. It is section 188. Section 188 says, an agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such act. An agent having an authority to carry on business has authority to do every lawful act, a lawful thing necessary for the purpose are usually done in the course of conducting such business. This section fixes the extent of an agent's authority in two ways. An agent has authority to do an act, number one. An agent has authority to do business, to perform an act and to perform the business. These are the two main functions of the agent, and the authority is exercised by the agent in these two manners. Number one, an agent has authority to do an act. Number two, an agent has authority to do the business. As a matter of fact, agent's authority is seen total of the power which his principal has given him, has caused him or permitted him to possess. It simply means that whatsoever is entrusted to the agent, that power is the power of the agent only. So he is not all powerful. He is powerful to the extent the principal authorizes him to do so. An agent is appointed in writing because it is convenient to do so. And in some situations, it is necessary to do so. Power of attorney is a document to make the others understand as to what powers an agent possesses. It is a document which aids all kinds of transactions to be carried out by the agent in the absence of principal, and the same would be binding on the principal. Section 189 says, an agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as would be done by a person of ordinary prudence in his own case under similar circumstances. This is what section 189 says. In emergency, he is authorized to do all such acts for the protection of the principal from the losses. So up till section 189, it is clear, as we have seen, that an agent is an employee. Number two, an agent performs all those functions which have been entrusted to him. Number three, agency is a relationship between the two, and the agency may be express or it may be implied. By implication or express words, it may be pointed. So the document of a power of attorney is created only for the purpose that it should be an enabling evidence for the purpose to deal with the third persons. The third persons expect that they should be aware of the authority and the power of the agent, so a document known as power of attorney is created. And the attorney has all the powers of emergency to restrain the losses which may usually occur in the absence of those powers. So the powers are given to him, but those powers are limited. But in cases of emergency, he may use the powers for the purpose of avoiding the losses to the principal.